Okay. Good evening. My name is Debbie Moore. I'm with Advisors with Purpose. I would like to welcome you to today's webinar entitled The Impact of COVID-19 on Your Estate Plan. So let me begin the seminar by introducing Dan Murray. Dan joined Opportunity International Canada in November of 2018. He is inspired by Opportunity's mission to help emerging entrepreneurs transform their lives, families, and communities. He strongly believes his primary role as CEO is to inspire, support, and serve Opportunity International Canada's leaders and staff, as together they will execute the mission with excellence. Dan lives in New Hamburg, Ontario, with his artist wife, Brenda. They have 3 amazing children, 1 awesome daughter-in-law, and a crazy beagle named Finnegan. So here we go, Dan.
Well, thank you very much, Debbie. And I just want to take a moment to thank every one of you for taking some time out today to join us on this webinar. For many of you, you've heard Lauren present before, and you know that it's always incredible value add. And if you haven't heard him present, well, you're certainly in for a pleasant surprise. I know he's prepared some very helpful and useful information, in particular around the issue of responding to the COVID challenges and estate planning. And I think this is the first time at OIC we've partnered with CNCF and Advisors with Purpose to do a webinar. Usually it's a phone seminar. So you get to see all of our wonderful COVID haircuts, or the lack thereof. As Deb mentioned, I'm the CEO of Opportunity International Canada, and I don't have a lot of words prepared because I want to save as much time as I can for Lauren. But as you know, Opportunity International, if you don't know, has been around for almost 50 years. Next year we'll celebrate 50th anniversary. Opportunity Canada celebrated its 20th anniversary in 2018. And we essentially work to help people work themselves out of poverty through financial inclusion, training, savings programs, and insurance. And it's an incredible, empowering ministry that truly makes a difference in individuals and their families and in their communities. Opportunity Canada serves in Haiti, Honduras, Dominican Republic, Colombia, Nicaragua, Ghana, India, Rwanda, and with our global partners in a total of 22 countries around the world. But I want to speak just for a minute about the impact of COVID-19. Some experts are saying that this particular health challenge is an even greater economic challenge, and that in fact it has probably set poverty and job growth back in the microfinance sector by at least 10 years. Our clients, many of them are experiencing the same kind of shutdown that we're experiencing in Canada. And as a result, they're not working. And for many of them, stay at home or shelter at home means starve at home. The money they make that day is the money they use to put food on the table. And not only that, but if they're not working and feeding their families, they're also not making regular loan payments. And it is the loan payment that is the revenue for the microfinance institution partners that we work with. Now, these are not big banks. These are micro banks whose whole mission is to serve the poor. And so they don't have, huge access to lines of credit like other banks would do. And so if there's a 2 or 3 month shutdown in revenues from the microfinance clients, they're also going to suffer a liquidity crisis. So we're in a moment right now in time that is probably unprecedented in the microfinance sector. And so we've really pivoted in our own plans to raise funds in the immediate moment to essentially help our partners ride out the storm so they can be there for our clients when we come out the other end. And then we'll have to respond again at that point to provide some additional loan capital, because many of those loans are going to need to be renegotiated, some new capital provided so that our clients can get their businesses up and running and start providing for their families again. It's certainly a challenging time, but I think as I've reflected on this, there is no better opportunity that I can think of than microfinance, that financial inclusion and the opportunity for an individual to work themselves out of poverty. The microfinance sector will respond quickly. It's agile, it's resilient. And as we work with our partners and our clients through this time, you know, there'll be a lot of work to do, but I can't think of a better organization or a better approach than microfinance, so that you're really coming alongside individuals and empowering them to provide for their families. So that's what we're all about. And I'm just at this point delighted to hand the mic over to Lauren Jackson. Lauren, you know, is the president of the Canadian National Christian Foundation and Advisors with Purpose. And after 25 years in the financial services business, Lauren sold his company and left the for-profit world in 2002 to create the Canadian National Christian Foundation. Over the years, CNCF has grown into a family of ministries, including Advisors with Purpose, that help donors in Canada wanting to give more efficiently and with more flexibility. Lauren still serves as its president today. Lauren is a published author and public speaker on the subject of financial discipleship. He donates his time today to help us think through our end-of-life decisions and to be better stewards of God's resources. Lauren, thank you so much for being with us tonight, and it's my privilege to hand the mic and the screen over to you.
Well, thank you, Dan, and thank you everybody for being on the call. It's a great privilege to be doing this with a webinar instead of, as Dan said, we usually do this with a phone call. So this is kind of cool that we get to do it and actually see that my wife cut my hair. Yeah, you talked about that. Who would have thought that we would be in a time like this? I mean, this is just bizarre. I mean, I'm thinking as Canadians, how can we not have the Canadian Tire store open? Yeah, there's one for you. And then whoever thought I would be going into the bank, but I put a mask on before I go in. If I'd have done that a couple months ago, they'd probably had me arrested. But today, that's the way you have to do it. Or who would have thought I'd be buying gas for 69 cents a liter? I mean, yeah, things have really changed in our world, haven't they? And I don't think they'll ever go back to being the same, unfortunately. Or fortunately, some of it will be better and some of it will be worse, probably. But I thought it would be important to take a look at the impact of all of this stuff on my estate plan or on my will. And maybe I need to make some changes or update it. So let's do that. Let's get started. Let's see if we can get this thing to work here. There we go. So here's our agenda. There's some temporary changes been made to RRIF and LIF payments due to COVID-19. We'll talk about those. Will updates during a time of isolation. How in the world can I do that when I have to have it witnessed and we can't be together and all those kind of things? The executor's job. Yeah, it's getting more and more complicated. And there are some things we need to know to prepare our executor for their role. So let's talk about some of those. And then what if I own some US stock, or maybe I have a vacation property in the US? How is that dealt with when it comes to my estate? And then last but not least, we'll talk a little bit about trusts and where a trust might help in our estate. And then I'll open it up for questions, and Debbie will have your questions. So don't forget, she already mentioned that you go to the question and answer or Q&A section. It may be at the bottom of your screen. It may be at the top. I don't know where it is on your screen, but I would encourage you to go there and type in your questions, and then Debbie can ask those as we get towards the end. So let's get going. RRIF and LIF rules. Well, if you're receiving RRIF payments, you already know this, but there's a minimum withdrawal limit set every January. So if you're not there yet, when you turn 71, you will be. And so what happens is our RRSP then rolls over to RRIF or RRIF. And when we do that, it starts paying out. It has to pay out in the year in which you turn, following the year you turn 71. So yeah, bad news is I'm already receiving it. The good news is I get to spend it. Yeah, so, or at least some of it. So the RRIF limits, the amount you have to pull out is set a percentage of the value of the asset. And if you have it invested in the stock market, that's probably changed quite a lot, in fact, since January. So in January, your RRSP or RRIF may have been worth considerably more, probably maybe as much as 20 to 30% more than it is today. Well, if you withdraw the same amount, the same percentage, and it's based on your age at that time, but if you're drawing the same percentage out of your RRIF today, it would reduce it a lot more than it would have in January. That's the problem. And if you don't need the money, then why would you want to reduce the value of your fund so much faster? So CRA has looked at this and said, okay, we would allow you to withdraw 25% less than the normal minimum. I always like to put numbers on these things because I think that makes it easier for us to follow and understand it. So the example might be that before the change, your RRIF or LIF, Life Income Fund, by the way, which is a rollover from a pension plan if it was rolled over into a LIF. So you might have had to withdraw $10,000 previous to this change, but now it could be as low as $7,500. So if you don't, as I said, if you don't need the money, now if you need the money, it's not going to really help you, is it? But for those who do not require the money, they can reduce the amount they withdraw this year only by 25%. Now, it's not the first time CRA has done something like this. They did something like this in 2008, 2009, actually, when we had the major disruption there last time. So they've done it again. So just be aware that that's an option that you might want to consider. What are some other thoughts about RRSPs and RRIFs while we're on the subject? There is a withholding tax on your RRSP or RRIF when it flows into your estate. So if your will says, like a lot of them that I see, that I take all of my assets, divide it equally between my children, then RRSP and RRIF would fall into that. But it could be rather devastating to your, the tax could be rather devastating to your RRIF or RRSP. And again, be sure that you name, if you have a spouse, be sure you name your spouse as a beneficiary, because it can roll over tax-free to your spouse. Any RRIF or LIF can do that. And then, of course, the spouse would be paying tax on it as they withdraw it. So that's a good way. And I think most of us who have an RRSP or RRIF already set it up, pardon me, with a beneficiary. After that, if you had the correct contingent beneficiary, it could create a major tax saving. Let's talk, what would that be? Let's talk a little bit more about that. You see, here's the issue that we may not think about. RRSPs and RRIFs are a different class of asset than any other asset we own, because there's not many other assets that we own where we tax deducted the money we put in it and didn't pay any tax on it as it grew. And that's why the tax on it is so high when we do withdraw it. So therefore, if it's different than other assets, maybe we should treat them differently in our will or in our estate. So let's put some numbers on it. Makes it easier to understand, I think. Let's suppose that you have $100,000 and it was remaining in your RRIF at the end of life, so there's no surviving spouse in this case. The example I'm using here. What happens to that $100,000? Well, that would flow into your final tax return in addition to any other income that you would have. So it would look like this, folks. If you had a $50,000 income in the final year of your life, whoever does your final tax return, they call it the terminal return, guess what? It's going to show $150,000 of income. So it may put you in a very high tax bracket. In fact, you could incur as much as 40 to 46% tax on that RRSP. So that means that your estate would then have to pay possibly as high as $46,000 in tax on your RRIF or RRSP. Well, that would leave only $54,000 for your family. And here's the part that always grabs me. If you have 3 children, they'd get $18,000 each and the government got $46,000. Well, now I'm not happy. Good job I'm dead. Good job I'm not here, because I wouldn't be happy about that one, would I? So here's a solution. And I think this is a good solution. I mentioned earlier about having the proper contingent beneficiary. That's just a fancy word for secondary. So Canada Revenue Agency says if you have a secondary beneficiary being charity, then that money can pass directly to the charity. So hear this, folks, it doesn't have to go through your will because it's a named beneficiary on your RRSP to charity. So no probate, no legal fees or any of those kind of things involved. So yeah, that could be a good way to do it. And then because it passes directly to the charity, the charity issues a tax credit back to your estate, and it would offset all that $46,000 of tax. So wouldn't everybody want to run out and add a secondary beneficiary? Maybe, maybe not. You know what? It's going to depend. And that's why we're having this webinar tonight, is to help you think through some other ways of doing these things. It might be that you have other assets in your estate that it would be better to gift those to charity and give your RRSP to your kids. Yeah, that can very well happen, and it might be better tax-wise to do that. But that's why very often I find Canadians need help with this. They need to know what are the best assets to give to my kids and what would be the best assets to give to charity from a tax perspective. And good news, we can help you with that. And I'll talk about that in a few minutes when we get closer to the end. Well, that's RRSPs and RRIFs. What about our will when it comes to updating it today? What if I want to redo my will? Well, I'm in isolation. How in the world is that going to work? Well, that's a very good question, because we do know that in most provinces in Canada, we need 2 witnesses to any will, and they have to be in person. So now you got 3 people together, because you got the testator, which is the person making the will, and 2 witnesses, and they're writing on the same paper and they're close together. And yeah, that can create some issues while we're in isolation. Oh, and by the way, here's another one. The beneficiary cannot be a witness, or they're eliminated from the will. So I'm isolated at home. It's just my wife, Doris, and I here. Well, now what? She can't be a witness because she's also a beneficiary. So it would eliminate her from being beneficiary. So therefore, I got to go find somebody else. Well, my daughter lives close by. Well, yeah, but she's a beneficiary, so she can't be a witness. And my son-in-law and anybody that's connected to that witness by family membership can't be a witness either, to the beneficiary, sorry, cannot be a witness. So that's going to create some issues. Well, what if I just handwrite my will? What if I just handwrite a will at home? Maybe I wouldn't need a witness. Well, you know what? You don't. Yeah. In some provinces, you can actually do a holograph will. So here's some of the issues. The risk of writing your own will. Here they are. Newfoundland, Nova Scotia, and BC wouldn't accept it. It's not a legal will as far as those provinces are concerned. So that's a problem in those provinces. So what else? Well, the other provinces will accept a handwritten will. By the way, it has to be handwritten. It can't be typed. That doesn't qualify as a holograph will. So I've even heard of lawyers putting the wording together, giving it to somebody by email, and then the person handwriting that out. So yeah, you could do that, and you don't need a witness to that. So that could be a way to do it if you're not in those 3 provinces. But there's also a huge risk of error or maybe misunderstanding. So maybe you failed to name who the executor is going to be, or not disposing of the entire estate. You missed something and there was no residual clause that said, here's how we deal with those kind of things. Or maybe ambiguity in the wording that I find for me was clear, but when somebody else reads it, you know, I'm sure we've all had that happen with emails. You send an email to somebody and you think it's very clear, and they misunderstood it, took it as something totally separate, something different. So how do you deal with that one? So that's some of the risk, I think, of writing our own will. But here's some solutions. There are some solutions for this. You could do online will preparation, joint wills and powers of attorney. How do you do that? Well, here's an organization that does it, and we have a connection with them. So their website is www.legalwills.ca and then /advisors with purpose. or AWP. The reason you put AWP there is you get a little lower rate for doing it. And so in this, I've gone on and done it. It's very easy to do. You can do your will online. It asks you all the right questions. You end up with all the kind of information that you should have in a will. And you can even have a lawyer review it with you electronically or by Zoom or by phone. So you could have the lawyer on the other end at Legal Wills review it and say, yes, this is that's exactly what it says. You got it right. And but now you still have to have it witnessed. Here's another way you could do it. We have a lawyer that we work with, actually out of London, Ontario, but he can do wills in all provinces. He can do powers of attorney in Ontario only. So he can do wills in all provinces, power of attorney. If you're interested in him, it's very inexpensive compared to most others. It's like $300 for a mirrored will, which means double will. If you're in Ontario, it's like $500, includes a power of attorney. So he's pretty inexpensive and very thorough and does that kind of stuff all the time right across the country. So that's another option. And there's an email address for us if you want more information about that. You could have your own personal lawyer. And now we have such a thing as a virtual witness, at least in Ontario. And I'm going to refer to this a little bit more later on and what other provinces are. But on April the 8th, the Attorney General in Ontario, under the Emergency Management and Civil Protection Act, now there's a mouthful, announced that during the current emergency, wills and powers of attorney can be witnessed remotely. Okay, so here's the conditions for that. The technology used must allow for participants to see, hear, and speak each other in real time. So in other words, it has to be a system where all three, the testator, the person making the will, and the two powers of attorney have to be able to see each other. They have to be able to hear each other, speak with each other, and all have the same copy of the will that you're trying to get witnessed. At least one of those witnesses must be a lawyer or a paralegal. So the other one could be your neighbor or somebody else, okay? It is vital that the witness carefully go over the will with the testator. So the witnesses have to work together with the person making the will. They need to read through it together, make sure that yes, I understand what's going on, and that's what I'm signing off on, okay? A couple other things. Similar arrangements are available in Quebec and in Saskatchewan. Little bit different rules, but kind of get you to the same place so you can actually have it witnessed from afar or through use of technology. Whereas BC and Alberta, you cannot do that. They have not put that in place. However, they do deal with wills a little bit differently in that if you did a will and it maybe wasn't properly witnessed, but it was turned into the law courts, they could actually approve it. Where in these other provinces, the court will not approve a will that's not properly witnessed. Alberta and BC, they can and they will. So that's just a little bit about those provinces. Here's another change due to the pandemic. Hopefully you already knew this, or if you didn't and you haven't filed yet, it's your lucky year. Individual tax deadline is no longer April 30th, just this year, and is now June 1. And you're also permitted to defer payment until August 31st without penalty. So as you know, that interest penalty, they like to charge us. You know, I always wonder, why do they charge me interest, but if they keep my money, they don't pay me interest? Yeah, maybe we won't go there. The money they're throwing out these days, they're going to need a whole lot more, trust me. But so those are some rule changes for our taxes. So if you have not filed or have not paid yet, there you go. You can actually file on June 1 and pay it on August 31st without penalty. Well, what about my executor? I said at the beginning in the agenda that we were going to talk about executors because it's getting more and more complicated. So let's do that. Your executor is appointed as the personal representative of your estate. So I'm sure if you have a will, and by the way, if you don't have a will, yikes, please get one. Yeah, you need to know some of the things that it says. You do have a will. The government creates a will for us, and it has some really strange things in it if you don't have a will. So it talks about how, just give you a couple of quick examples. If you don't have a will and you die without a will, that's called intestate. And then they would, the money, any asset you have would all be liquidated, and half of it would go to your spouse, providing you have one. And the other half would go to your child. If you have 2 children, well, they're going to get 2/3 and your wife's going to get 1/3, or husband. So you can begin to see already that that can create some issues. So have a will. So your executor is the person you've appointed to be the representative of your estate. Now, you need to understand the estate is not an independent entity. In other words, the executor is totally responsible for them. So the executor is dealing with this on your behalf, really, because you're, of course, no longer here. So that's their job. They have a fiduciary duty to the beneficiaries. So those who are in the will, they have a fiduciary duty to them. And if your executor is also one of the beneficiaries, that can complicate things a bit, but that's okay. You can do that. Executors are also liable to the beneficiaries and the creditors. So if executors make a mistake and give the money out to the wrong people or the wrong amounts, they are accountable. Yeah, so you might want to make sure that your executor is aware of that before they start into this. They need to be a Canadian citizen. Yeah, if they're not a Canadian, if your executor is your son or daughter and they live in the States, I would strongly encourage you to find somebody else to be your executor. That's probably not going to end up going well for your estate when the time comes, nor for them while they're living in those other countries because of the tax issues between countries. So I'll just leave it at that without getting too complicated. So your executor should know the location of your will. They're going to need an original copy for grant of probate. So if it's with your lawyer, okay, they need to know who your lawyer is to go get that. Or they need to know at least where it is that they can get their hands on it. They need to have an up-to-date address of all the beneficiaries. So if there are beneficiaries there that may not be ones that they would normally be in contact with, they need to know where to reach them. They also need to know where your bank accounts are, your insurance policies, your credit card, birth certificate, and marriage certificate. Wow, that seems like a lot of stuff, doesn't it? Well, they do. My dad passed away in September of last year, and the first thing I had to do was show the birth certificate and marriage certificate to the government so that my mother could continue to receive the CPP benefit that was coming to her. So yeah, you're going to need to know where those, your executor needs to know where those things are. Should return the driver's license and health cards along with a copy of the death certificate so they know why you're returning them. And of course, if the driver's license still has more time on it, you get a refund for that, but those should be returned. You should file a final tax return and ensure that CRA gives you a tax clearance certificate. So when you're filing a final tax return, you want a tax clearance certificate because you want to make sure that Revenue Canada can't come back later and say, hey, we found some other income. We think this guy or gal owes us more money. And now there's a lot of interest included on top of that. You don't want to get into that situation, obviously, for an estate, because now you've already given the money out to whoever the beneficiaries were, and you don't even have any money to pay it. But yet you as the executor are responsible. So once you get a tax clearance certificate, that's it. We're done. We don't have to worry about that anymore. So some other estate issues. So you may be a Canadian who owns property situated in the US that would be subject to US estate tax. Now, I know when I say that, you automatically think, well, I own a condo in the US, or I don't, but maybe I don't own any real estate in the US, so I don't have to worry about it. Well, not so fast. So it includes real estate property or real property, yes, as well as shares of stock issued by a US corporation if they're held in US dollars. So for example, I have some US corporate stock that I hold with Nesbitt Burns as my investment advisor. Well, that qualifies. Let's put some numbers again. You know, I'm a numbers guy. I was been in the financial planning world for 35 plus years. So that's kind of what I gravitate back to and say, okay, let's get some numbers on it so we can understand it. So let's suppose you own a condo in the US, and there you can see the value there, 280,000, maybe a car. If you died in that situation, your estate tax due to the IRS would be $78,000. Now, if you know US tax very well, you know that they have an estate tax, but they also have a threshold that you have to go over. Well, that's true for US citizens. That's not true for you and I as a Canadian citizen owning properties situated in the US. So there would be no freedom there, except that, hey, here's some good news. The solution is your executor needs to know this. They need to file a US tax return within 9 months of the date of your death. Yeah, this is very key right here. So file a US tax return within 9 months indicating that you're a Canadian taxpayer and that you own this property, et cetera, and that you're paying tax in Canada, and then the US tax treaty with Canada will remove all the tax that would have been owing in the US. So you're way better off paying it in Canada, because in Canada, they would have taxed you on the gain of that condo and nothing on the car. It certainly wouldn't have gained, I don't imagine. So yeah, make sure that your executor knows if you own any US stock or any property in the US, make sure they're aware that they need to file a US tax return within 9 months. Let's talk about trusts just for a moment. Not a lot of use for trusts in Canada, but there are some special uses. Inter-vivos trust means living trust. So this is something you do while you're alive and you manage it while you're alive. Testamentary trust is just as you might expect. It's after you're dead. It's after we're gone. We've graduated to heaven and we left whatever behind in a testamentary trust. So let's take a look at those. Here's some uses of a living trust. First one would be if you have minor children. According to the Ontario rules, 10% is the max, or sorry, $10,000 is the maximum that you could leave in your will to them. So you could not leave more than $10,000 to a minor child in your will without it being going into a trust. So you need to set up a trust for children. So you do that while you're alive now, so that if anything should happen, those children are taken care of. Here's a Henson trust. If you have this is designed to work for disabled children, to work around the provincial asset test that they use for eligibility for assistance for a disabled child. So if you have a disabled child that is receiving disability income from the government, the last thing you want to do is leave them a chunk of money that shuts that off, because when the money that you've left is gone, now they got to try to get back on the provincial payout, and that's going to be really tough. So set up a Henson trust. The money goes into the Henson trust, and it does not affect then the asset test for the province in being able to keep paying for this disabled child. So there's a couple examples. What about a spousal trust? Not often used, but if it is used, it's usually because a spouse has trouble handling money, or maybe a family trying to borrow the money. I've seen this actually. I saw this at work. the widow received a chunk of money, and the next thing you know, all of a sudden, some of the family relatives had this great business they were wanting to start, and they wanted to borrow the money from the widow. The widow felt obligated to give them the money because it was a brother-in-law. What were they going to do? So they did, and of course, as you know the rest of the story, the business didn't go well. They lost the money, and now the widow is out. So if it had been in a spousal trust paying her income for the rest of her life, she could have just said, I can't give you that. I don't have access to it. Another one would be second marriage. If there's a second marriage, sometimes it's good to have a spousal trust, again, to protect that income for the spouse. When you put money in a living trust or an inter-vivos trust, you become the manager, or as we like to call it, you're the trustee. So you're the one managing it, investing it while you're alive. And you could actually use a trust while you're alive. I've seen people use trust for their children while they're in university and set up to that the Inter-vivos trust might pay to help with their education. There's no big tax advantages that way. It's more an advantage of being able to manage the money and not have it being spent by a university student and bought a new car and now has no money to go to university. What about testamentary trusts? Well, usually the income from the trust goes to the spouse until death, and then the remaining assets would go to the next of kin. So in other words, usually, again, this would be more like a spousal trust set up where once I die, the money's in the trust, it pays out to my wife an income every year. And this again would protect the family member coming and trying to borrow. And then when my spouse dies, then my kids or whoever I specify in the trust would continue to receive the income from it. So that's the way that would usually work. Some advantages: if you have a qualifying spousal trust for tax purposes, it can allow you for a capital gain rollover in a trust without triggering tax. So that's good. I mean, you can roll over other assets in that. Here's a good one. Trusts are not probated. So you don't need to take a trust to probate. So that might be another reason you might want to consider a trust. And then there's one other. What about a charitable trust? See, you can put assets into a public foundation, like, Dan already mentioned that I was the president of the Canadian National Christian Foundation, which is a federally registered public foundation that serves Christians across Canada. But you could set up your own foundation inside of it, and it's a charitable trust, and it allows you to get a charitable tax credit when you put the money in, and then you're able to advise that foundation as to how to distribute that asset to your favorite charity at a time that's best for you. So you get a tax credit right up front, but you can give the money out over many years. So that might be a good time to set up a charitable trust when maybe you sold a business or you sold a piece of property and you got a huge capital gain. That's where a charitable trust can really come in handy. And there are some major tax advantages, of course, to that one. Well, we've given you a lot of information already, and let's see our time. We're 40 minutes in. So now what? Well, here's a stat you should be aware of. According to Forbes magazine 2018, 70% of estate transfers fail to meet the objectives of those leaving it behind. Wow, 70%, 7 out of 10 fail. Why? How? What's that about? Well, how do you be sure you're not part of the 70%? I got some good news for you. Advisors with purpose are available to help you put a plan in place. That's what we do. And by the way, there is no cost to you to do a plan. And I'll tell you a little bit more about that in a minute. I'll just leave it at that. Oh, no, I won't. I'm going to tell you right now. There is no cost. And the reason for that is because Opportunity International partners with us to provide this webinar to you. And it also partners with us to provide the estate planning that you so need so that you're not part of the 70%. So there is no cost to you for this. So here's how it works, folks. It's pretty simple. All the meetings are by phone. Yay. Hey, we've been doing this for 10 years like this, so we were all ready for COVID-19 social distancing and all that kind of stuff because we've been doing it by phone this long. It's usually 2 to 4 phone meetings over time. We're very advanced on the technology side, but you don't have to be. If you're one who says, hey, email is about all I can handle, that's fine too. But if you got on this webinar, I would say you're doing pretty well. It's always confidential, folks. There is no information fed back to Opportunity International or anybody else about the conversation that you have with the estate planner. They're there to help for one reason, and that's to help you understand the outcomes of the decisions you're making and help you get to the place where you can say, hey, now I know which would be the best assets to give to my children and which would be best assets to give to charity. At the end of those meetings, we'll provide you with your personal estate plan that you can then have a conversation with a lawyer to get it into your will and even help you in preparing for updating your will. So all of those things fit in there. And yeah, you can be sure it's going to be focused on the most tax efficient method that there is. That's one of the things we're always looking for. So we're doing 2 things, trying to help you make wise decisions with the information that you need, because lots of times people don't know what they don't know. And therefore, that's why the 70% number that I referred to earlier. So let me stop there and see if we have any questions, and I'll get a sip of water while I do that.
Okay, great. Just one question here, Lauren, just a second here. Oh, it's in French. Unfortunately, my French is not so good, but the good news is, and neither is Lauren's actually. So
I can read it though. It's just asking
okay.
if there be a translation of this presentation available from French to English.
Okay, so the answer
or
to
from
that
English,
is
English to French, sorry.
Right. Unfortunately, the answer is no to that. But the good news is on staff, we do have one of our estate planners is totally French and bilingual. So if you have questions, feel free to and actually I was just going to mention that my colleague, her name is Tanya Rust. Her email comes through as the word trust, T-Rust, at Advisors with Purpose. She will be contacting you in the next few days with a link to this webinar and also a link to the scheduler. So in that case, you might want to connect back with Tanya specifically and say that you'd like to speak with one of our bilingual advisors, and that way they can help you out. There's another question here. Do tax and estate laws significantly change over time? 10, 20 years ago down the road, 10 or 20 years down the road, will our current plan still be best? It's a great question.
Yeah, that's one of those, yeah, I don't know questions. I always say you should review your plan every 5 years anyhow, because things change. Things change in my family. For example, when Doris and I first did ours, we owned a business together, and now we don't. We had kids at home, and now we don't. All those kind of things change over time. So I usually recommend that if nothing changes in your personal family, at least every 5 years, you probably should have one of our estate planners review it again with you, just to make sure that laws haven't changed or anything that affects it in a negative way. So that's always a good thing to do. So 10 or 20 years down the road, yeah, who knows? I would say review it every 5 years or so, and then that way you could be up to date.
Great, good. Someone asked if most of the content today was about Ontario. Is this available for across the country?
Yeah, I tried to bring in as much as I could about the other provinces. When we talked about wills, you'll recall I talked about quite a few of the provinces: Nova Scotia, Newfoundland. I talked about Quebec, BC, and Alberta and Saskatchewan. So We missed Manitoba, I know, in there. I was on a seminar earlier today, or a webinar with a bunch of lawyers, getting a little bit more information, but they didn't talk about Manitoba at all. So I don't know the answer to that area, but I try to cover off as much of the area as I can. Most of the stuff, as far as your estate is concerned, here's the thing you need to know. Our estate planners know the rules for every state. So whatever, or every province, sorry.
Province, yeah.
whatever state, yeah, I got too many states in there. Every province. So our estate planners start to work with you. It doesn't matter what province you're in, they know the rules for there. So that's the people that you need to know those rules even more than me knowing them. So
Good. Okay, just one more second here. There aren't any more questions yet, but let's just give it another second. Actually, if you want to come back on, Dan, and just wrap up, and we'll wait just if any more questions come on while we're waiting.
Great. Well, Deb and Lauren, I just want to thank you on behalf of Opportunity International Canada and the participants this evening for a very informative presentation, a timely and informative presentation. And I know, as was noted at the outset, Lauren, you are doing this essentially pro bono tonight. So thank you so much for making your time available, and Deb for all the great work you've done. And a shout out to Steph, who's not visible, but has been instrumental in helping organize all this as well. So just once again, thank you so much to everyone for taking time to sit in and listen to this presentation. Let's see if we have any more questions before we wrap.
We do. Another great question here. And it's one I think a lot of people have. Can you explain probate, please?
Yeah, good luck with that one. The good news is, it was for a while there, it seemed like everybody wanted probate. Banks wouldn't allow money out. If it was $5,000 in grandma's account, they wanted probate. They seem to be backing off of that now. That's not nearly as important. Probate is simply the provincial court, so whatever province you live in at the time of your demise, the provincial court then ruling on your will and saying, yes, this is the most current will, up-to-date will. This is the last will this person wrote, and therefore you can take this to the bank. In other words, you can use this as legit. That's important, and here's why. That's important to the executor, because the executor, if I'm your executor, I want to know that when I give out the assets that are in this will to the people that are in this will, that I'm not going to be wrong at the end. And once the probate court approves that that's the current will, and that executor does what's in that will, then they're protected, because the probate court is then on the hook if they made the mistake on that. So there are some advantages to probate. Probate mostly happens now, it seems, when there's real estate or some hard asset like that, rather than cash or RRSPs and some of those kind of things. Debbie, before we go, let me just add one other thing. I mentioned earlier, and I didn't come back and finish on it, that the estate plans were free. There's no cost to you to do these because of Opportunity International. I just want to say, when Opportunity International asks us to help them with this, there's never any indication that you need to give something to them. That's not what this is about. What this is about is them saying thank you to you for your years of support and involvement with Opportunity International. And because I know these people, I've been involved with them for years, and they do a great job. But I just want you to know there was no lean on this that says, oh yeah, well, you got to do something for Opportunity. No, never has ever come up. It's to help you make wise decisions in their way of saying thanks.
Great. Actually, one more question just came in. We'll just nip it in here really quickly, following up on the probate question. And so what is the cost of probate, assuming there is a cost?
Well, there is a cost, and it varies by province. It's rather low. It's usually like 1%, maybe a little less than 1.2, 0.7% sometimes, depending on the province you're in. But it's of all of the assets that go through the will. So one of the things that our estate planners do is they are always looking for ways to pass assets outside of the will. And I talked about some of them tonight, like named beneficiaries pass outside of the will. So they'll be looking for ways to do that to keep those costs down. But yeah, it's not large, but if your estate is large, it can count up.
Okay, great. Good. I'm just going to wrap up then. Thank you, Dan. And Stephanie, as he mentioned, is the behind the scenes there from OIC for inviting everyone tonight, for being part of this evening's presentation. Thanks, Lauren, for all the great information as always. And thanks everyone for attending. We've learned a lot tonight. Look forward to hearing from Tanya Rust with that email, and that will be coming in the next few days. Okay, thanks everyone. Stay safe.
Thank you.
Thanks, Dan.
Thanks a lot. Good to see you guys.